So in this section right here, on section 17, this is just talking about the parties involved in this contract. And the parties that are involved in this contract is the seller and the buyer and their actual heirs and successors are also responsible. So if anything happens to either party, this contract transfers over to the respective heirs. So this is what this part is talking about. And this survival portion, it almost is talking, sounds like it's talking about if someone passes away or something like that, and whoever survives maybe is responsible for the contract. This is not what this survival is meaning. What survival is meaning in this section is whatever the seller said that they were going to do at the beginning of the contract with the repairs, and we are beyond the due diligence repair request, and actually we have even gotten to closing. They are still responsible for completing those actual repairs that they said that they were going to do, because sometimes things get a little bit hectic and contractors are backed up, and or sellers they don't have the monies to actually get the repairs done during the contract. Then we draft up something, an addendum stating that they will get the repairs done after closing because they're going to use their proceeds to do XYZ. So if we come up with that and addenda and everybody signs, this is still binding even though the contract is over. So this is what this section is saying. Whatever the seller said they're going to do, even though we're beyond closing, whatever is stated in this contract is still binding, and that party is still responsible for taking care of that particular item. So this section here, the entire agreement is being recorded with the court, so there's not going to be any changes to this contract. If there was any changes or is any changes that's going to be done, it has to be in writing. There's no deletions, additions or deletions here too, must be in writing and signed by all parties. So anything that it needs to be changed in this contract, it has to always be signed by both parties. And so what this section is just talking about is the ways of communication that the party agrees upon at any time between them are relating to this transaction contemplated by this contract may be conducted by electronic means or whatever means that they have decided to communicate in. That could be electronically, that can be written by mail, sent by mail, electronically, so on and so forth, even from party to party. As a buyer's agent communicates to the seller's agent, it's basically like the buyer communicating to the seller. So we just need to acknowledge all of that as being methods of communication. Okay, in this section 21 is talking about the execution of this contract. It reads that the contract may be signed in multiple originals or counterparts, all of which together constitutes one and the same instrument. So this section is talking about here when this contract talks about days, it's talking about consecutive calendar days, except for that one section that we were talking about earlier with the earnest money when it said one banking day. That is pertaining to that situation with the one banking day and that situation only. But anytime the contract speaks of days and times overall, unless it's specifically speaking, like in that earnest money section, we're talking about consecutive calendar days. And that's including Saturdays, Sundays, and holidays, federal days, states, locals, or even religious days. So this section here, 23A, is talking about a breach of the buyer by the buyer. So what this is saying is that in the breach of the buyer, the seller is owed that due diligence fee and that earnest money deposit, and that serves as liquidated damages. So in the event that the buyer breaches for any reason, whatever the reason is, after that due diligence period, that's a breach of the contract. If you terminate within the due diligence period, then you will receive your earnest money back, but not the due diligence. But anytime after that, it's a breach, and the sellers is owed those fees for liquidated damages. Now, in Section B, this is a breach on the seller side, and in the event of a material breach of this contract by the seller, the buyer may elect to terminate this contract as a result of such breach and shall be entitled to return of the earnest money. So what this is saying, that if the seller's breach, the buyers will receive their earnest money back and their due diligence back. However, in addition to that, any other fees incurred by the buyer in connection with this particular sale. So if they lost their money for an appraisal, like I said, if you complete the contract, the lenders is going to take your credit card and hold it. But if the contract is terminated for whatever reason, then they're going to charge that buyer's account for that appraisal. So the seller will owe them for the appraisal or any inspections, other inspections that they paid for during that time. The earnest money and the due diligence, that's normal. That is supposed to go back to them, but they incurred other fees associated with this contract. So if the seller breaches the contract, they're owing the buyer all of those monies that were, and that's for anything connected, anything that they did connected with this contract to that point. The sellers owe them that money back as well. And here we are in Section 23C. If the parties have to go to court for whatever reason, for, let's say earnest money, deposits, or due diligence fees, or any other costs, if that party has to take the other party to court for anything, then that other party has to pay for those court fees. Because if the other party didn't do whatever they did or did not do, the opposing party would not have to have taken them to court. So those fees shouldn't be they shouldn't be responsible for those fees. The one that's being taken to court for whatever reason, whatever they did or did not do to bring this situation to court, they're saying that they should be responsible, and they are responsible for paying the court fees. And again, we're needing initials here at the bottom of the page. Okay. So with this, so we have a note here, and what this note is saying, just in addition to what I just said earlier, that whatever party is seeking recovery for the attorney's fees, that they must give the other party 5 days notice, written notice from the time that they sent off the mail to pay for the outstanding amounts. So that's what this section is saying. Okay, so in this section here, it is saying that the North Carolina Association of Realtors and the North Carolina Bar of Association makes no representation as to the legal validity of the adequacies of any provisions of this form in any specific transaction. So if you don't understand this form in any way, they're telling you to consult a North Carolina real estate attorney. So the North Carolina Real Estate Commission does not create these laws, and NAR either. If you have an issue with the form and what it's stating, or anything that it's saying that you have an issue with, then we need to consult an attorney to give us advice on this particular addendums. So we're at the last section here of this contract, and this section is saying that this offer shall become a binding contract on the effective date. And like I said, the effective date is when that last party signs, unless specifically provided otherwise. Buyer's failure to timely deliver any fee, deposit, or other payment provided for herein shall not prevent this offer from becoming a binding contract, provided that any such failure shall give the seller certain rights to terminate the contract as described herein or as otherwise permitted by law. So in this section, we're going to be looking for signatures and dates from the seller and the buyer. If it's an entity like an LLC, then that's where this information will go. If the buyer is an entity, has a LLC, or if the seller, that's where that signature would go, and they want you to print the name and the title of this particular person and date it there as well. And so on this page, there's no initials required. This is something that you would need to read just to be careful when you're doing any type of wiring of your closing costs and any other monies. It could be your due diligence or earnest money. Whatever you're doing, whenever you're doing wiring, you just need to take these necessary precautions. And then there's initials here stating that you read that and you understood it. Okay, and this is the notice of information page, and here's a note here that insert at least one address and or electronic delivery address each party and agent approves for the receipt of any notice contemplated by this contract. Insert in A for any which are not approved. We're going to obtain the buyer's information, their address, mailing address, and all their information here, and the seller the same thing here, and then the confirmation of the agency addresses. So this is where the selling firm is going to put their information and the listing firm is going to put their information. Then it also has a section here for the individual selling agent's name. So this up here is where the firm name goes, and then the agents themselves, that's where their their names go. And if they're acting as dual agency, they would check off that box. If they're not, it would just be they will leave it unchecked. And then there's a slot here for their license, their phone number, if they have a fax, and their email address on both sides for the listing side as well. So that's where our information go, even though this contract is between the sellers and the buyers, there still has slots here for the agents. And then this section is requesting signatures as well. I don't know why my signature block is not highlighting the sellers, but that's okay. We are almost done. And this is the last page of the contract. This is the acknowledgement of receipts of monies. We're going to get the seller's signature here, name here, buyer here, and the property address that they're purchasing, the 123 Main Street. Here is the section where the listing agent is going to acknowledge that they received the due diligence receipt. We always need receipts when we are exchanging monies, and so the amount of the due diligence is going to be there, and the firm is going to sign stating that they received that. Now this second one where it highlighted it, this is acknowledging, the sellers is acknowledging that they received it. So the listing agent gets it and they give it to the actual sellers. The amount needs to be in there, and the sellers need to sign that they have received it, those the due diligence. And then also the escrow agent, we're going to deliver that earnest money deposit to them, the amount of that deposit, and then we're going to need signatures by someone that received from that firm, someone that received those monies. And if we had any additional earnest money deposit, when we go back there on the 15th, like we had discussed before, we're going to do this one on the 1st, and then if we have an additional earnest money deposit, we're going to take care of this one on the 15th. We're going to put the amount in here, and then we're going to have that person signs, whoever is received that particular additional earnest money deposit. So, and then once we do that, we're going to go ahead and get this off to the attorneys and the lenders so they can reconcile these numbers that you have deposited these fees in here, so you can get credit for this at the end.